So thank you very much for having me in the summer school. I was looking forward to joining you in Valencia, but the situation does not allow. So apologies for not coming in person. I will try in 20 minutes to look at the main legal tools that we can use to build trust in digital platforms. And when I say legal tools, I have a broad understanding of what are legal tools. And we will start with things which are more hard law, and then we will go towards tools that are developed by platforms, but which are akin to rules or legislative rules made by the platforms. So as Andres presented a bit earlier, we don't need to go back to what are platforms or collaborative platforms or digital platforms. But for the sake of the argument, I will be looking here at platforms which are operating with third-party listings, and I will exclude platforms which are providing their own content. I will only look at platforms which are providing and using intermediation as their main business model. So there's a very vast literature on how to build trust on the internet and how to build trust in the context of digital platforms. This set of literature has been expanding since the 2000s, but four main dimensions need to be identified when we talk about digital platforms. The first dimension to build trust is that platforms need to be accountable. The second dimension means that platforms need to be transparent, and transparency has different features. Transparency may mean that you know who is operating on the platform, but also whether the good is of a good quality. Being able to predict the behavior of the platforms and of other people using the platform is also a core element of building trust in the digital economy. Last but not least, there is a security and safety feature in trust in the digital economy and digital platforms. These four dimensions can be used in different ways, and I will try to look at the different tools that have been set up by the European levels or by local authorities, as well by the platforms themselves. And a tool that has been out there for a very long time has been to develop online conflict resolution. The fact that when you've got an issue, you know that you will have a place where your claim can be heard is a way to increase accountability. But it does not really help you have a transparent, predictable, secure, or safe environment. This online conflict resolution aspect was developed already in the 2000s, at the other time as other tools were being built. Andres already mentioned the fact that the e-commerce directive made platforms not liable for the content provided by third parties. This really removes the first feature of building trust in the digital economy. Being accountable would help make platforms more trustworthy. To some extent, it may make platform transparent, but definitely not more predictable or more secure. So you need to go much further than just looking at the e-commerce directive and the articles 12 to 14, who make the platform not liable for the content provided online. So what can be done then? Well, Andres also mentioned very briefly that you could mention the Uber cases, and the Uber cases was about licenses. And licenses could be applicable and could be a signaling strategy, making the platform more transparent. Because if users have a license, or if the platform operators or the platform users have a license, there would be more transparency, because it would be more clear who would be operating, because usually with licenses given by public authorities, you need to have a background check, or you need to have at least some form of checks that they meet minimum conditions, and the name of the people at least is known to the public. So this makes at least some form of transparency. It does not really make any accountability, because in many countries, the licensing is not sufficiently enforced by public authorities. It does not really make any predictability, because some studies have showed that if you've got, for instance, taxis being licensed, you do not necessarily have a better quality than in other countries where the public authorities have decided that there's no need for licensing for, let's say, other form of transport on demand services. So this is one form of, or one approach towards regulating digital platforms. Another way to build trust would be to apply the trust services regulation. The trust services regulation, which has been adopted in 2014, tries to regulate the way that people sign online, and that the content of contracts is being checked between two users. So if you have a contract that you want to pass on, or you want to have signed with someone else on the internet, you can use these trust services to have it signed. The trust service will check what the content is and whether the message being conveyed from the sender to the recipient is accurate, and that it has been received entirely by the recipient. So you've got here a way to approach that what you expect and what is being sent and what is received is correctly matched. But this trust services has disincentives to be applied by digital platforms, because being considered as a trust service usually comes with a much higher burden. And while the contract is actually being signed, I don't know if you're going on Airbnb, the platform says that they do not participate to the contract between the host and the guest. Yet the contract is made on the platform, and as such, the trust services regulation applies to the platform. But they're not considered as qualified service providers. Yet, as they are a trust service provider, they fall within the scope of the regulation. But supervisory authorities do not look much at the real role of Airbnb and other platforms in checking the identity of the recipients and of the sender of the contract. That the message conveyed from the sender to the recipient is actually correctly conveyed, and that it is actually entirely received, and that there is a match between what the sender and the recipient receive. So here again, you've got some form of transparency, because you've got the licenses. There's some form of very limited accountability, because the public authorities in charge of surveilling, watching the application of the trust services regulation do not actually enforce it against digital platforms. Going more into tools developed by digital platforms, platforms try to make recommendation systems. This is how they believe trust should be built, or one of the ways that trust should be built within the digital economy. Yet, there is no real definition of what a recommendation is. Most platforms use at least some form of rankings. Ranking systems are any kinds of systems where, because you've got a limited space, you need to classify the results that you're showing to the users. This instrument is being regulated by European law, and especially by the platform to business, the P2B regulation adopted in 2019. But this instrument does not make any form of accountability at all. It is a regulation, yet in the regulation there is no sanction mechanism set in place, which is very surprising for a regulation. It leaves member states to say it needs to be applied. It doesn't say any how, why, any means. It just says it needs to be applied by member states. I don't think there is any member state that have actually entered or adopted any transposition mechanism for these sanctioning measures, while it should have been done by last year. This is very surprising, and people at the European Commission told me that it was the purpose of this instrument was not to have increased accountability, but it was certainly an exercise for them to know what were the good and the bad practices, because there are some reporting duties and some transparency duties in the P2B regulation, and especially with regards to rankings. Ranking systems need to be more transparent, and how the results are being ranked needs to be made and disclosed to the public. And this is what the European Commission, when they made this proposal, wanted. It wanted to have more transparency, yet there's no enforcement of this transparency, which is therefore very difficult to actually assess in practice. So here we've got a transparency component, but no accountability, no predictability, no security or safety. So again, very difficult to have the enforcement and to have trust in the platforms with these tools. Then you may look at other tools, for instance, online reviews, online ratings. So you may all know that reviews and ratings are present everywhere around us in our societies and digital societies. Yet the platform here is not or very little accountable for the content posted by third parties. There is few recently introduced provisions in terms of consumer protections with regard to reviews, but the platform is not itself liable for the content of the reviews or of the ratings. It is supposed to make things more transparent, but we have seen, and there are many illustrations of situations where these reviews have been used in abusive manners. It has been, they have been used in abusive manners even to scam people or to make goods which were unsafe better ranked on Amazon, or instruments or services which were inherently unsafe higher ranked on digital platforms. So it does not really help having ratings and review systems to have a better and more trustworthy environment. So these recommendations do not lead to much form of responsibility. On the side of review for the online reviews, the accountability is very limited, the transparency is very superficial, and there is none or little security. On the side of the platform, there are some instruments, as I said, in terms of consumer protections. Some instruments in financial law, the consumer, the credit rating agencies, which is a financial law instruments. Credit rating agencies are Moody's or Fitch. They are Standard & Poor's. Those are credit rating agencies, and the legislation applicable to them would also be applicable to digital platforms. Unfortunately, it's completely unenforced. What I mean is that these instruments were not meant to target digital platforms. Yet, when you look at the scope and the duties applicable to these credit rating agencies, they would also be applicable to digital platforms, because the credit rating is what platforms do. When they give you a score, they actually give you a credit rating. And you do not need to tweak any word of the regulation applicable to the credit rating agencies to have actually apply it to digital platforms. Some provisions are, of course, not relevant, but many of them would increase the transparency of digital platforms. Yet they are not enforced. So it is not really a way to increase the trust either in digital platforms at the moment. So I think I painted here a very grim look at digital platforms and tools that are out there and the way that these tools are regulated in order to build trust in the digital platforms. So far, the digital agenda developed by the European Commission and the European institutions is very disappointing. Of course, there are new ways and new approaches and new instruments being proposed in order to correct this. One of these tools would be to look at the DMA. I think other people are better placed than I am to explain the DMA, and I'll give that to them. So the DMA is a Digital Market Act, and then there's the DSA, the Digital Services Act, and in the DSA there is some way for hope. There is indeed some way for hope, because when you look at the new provisions, you see there is an increased level of supervision. And this decreased level of supervision leads to more accountability. You also find in the DSA the need for digital platforms to check the identity of traders. And there's a duty to know your business customer. This is an increased duty of transparency. Platforms also have a duty to report criminal offenses to the authorities in charge, to the public prosecutors in charge. And if they do not know who is the public prosecutor in charge, they still can go to Europol. So there's here, and Europol will be in charge of allocating the information to the right public prosecutor offices. This increases the security and the safety of the platforms and the users of the platform. Last but not least, digital platforms need to state the reasons when they exclude some users. They also need to have the sanctions for exclusion or the reasons of exclusion for users clearly stated in the terms and conditions. This not only increases the transparency of the platform, but it also increases the predictability of the platform and of other users' behaviors. Therefore, in the DSA, we say that we only start to actually develop the tools to build trust, whereas so far, all the tools that I mentioned are set to build trust, but in practice, they fail to do so. And I will stop here so that we can get some time for discussions and for questions. Thank you very much for participating to this event.